Thank you for tuning into the All Funds Investment Podcast. Today we have Ian Gobin, an owner and partner of Cummings Pepperdine LLP, a boutique UK law firm to investment managers and Web3 promoters. In this episode, we discuss a new piece of legislation called the EU AI Act. We dive into what the act is, who it affects, and then we focus specifically on the implications to investment managers based in the EU or who have EU investors. Just a reminder here that nothing said is legal, tax, or investment advice. Check out the full disclaimer below, as well as the links to connect with us and Ian. We hope you enjoy this conversation. Thanks for watching. Ian, thanks a lot for joining us today. So EU just announced an act called the European AI Act. What's this all about? Tell us a little bit about it.
Yeah, I've got to say, every time someone sort of says, "Oh, the EU are sort of they've got some new legislation," the first thing is everyone grimaces and just goes, "Oh my God, what are they doing now?" This is kind of that kind of situation, but I think overall it is good news, albeit we'll need some clarifications. But you're right. In December of last year, so December 23, the European Parliament and the European Council, they finally reached a political agreement on the EU's Artificial Intelligence Act, what they call the EU AI Act. It's a real front runner in terms of AI legislation. It's the first continent to really set clear rules for the use of AI. Being the front runner, it doesn't always work out. One word, Betamax, come to think of it, VHS, that had its day, and DVDs as well. So it's not always best to be the first ones out of the station, but you can't stop progress. You've got to start somewhere, and the EU has with the EU AI Act. I think the draftspeople and the adopting bodies in the US and the UK, they're going to look at what the EU's done here with the EU AI Act and create 2.0, 3.0 versions. Neither the UK or the US have got socialism at their core, unlike the EU. And I think that really, really comes across. The kind of the socialist core of the EU comes across with this EU AI Act. And don't get me started on the international efforts set out, or trying to set out guardrails for AI. The G7, G20, OECD, Council of Europe, the UN. None of those guys are going to get their act together, and by the time they do, it'll be terminated too. So at least the EU's done this. It's a start, and I think that there'll be improved versions from the US and from the UK. This really is the first piece of EU legislation that's been drafted and adopted from start to finish, which did not involve the UK. So this is all post-Brexit. Briefly on Brexit, although I'm a firm Remainer, gosh, I used to even work for the European Commission. That was a lifetime ago. And in DG15, that was responsible for financial services. I am a bit chippy when it comes to EU legislation, particularly with their approach to financial services and our investment funds industry. I think AFMD is my number one bugbearer, but hey, that's for another day.
So tell us about the act. So is this legislation that's open? Did it pass already? And tell us about specifics. What are they looking to do with this legislation?
Yeah, it has passed. It's not law yet. It is still. We'll come on to that in a bit, but it was adopted, and the politics is the most important thing with the EU. It's been passed. It is a landmark piece of legislation. The EU is really trying to seek and create a far-reaching, comprehensive legal framework for the regulation of AI across the EU. The aim is to ensure that AI systems are safe, they're transparent, they're traceable, they're non-discriminatory, and they're environmentally friendly. In other words, all of the EU's fundamental rights and values are protected. The aim is also to encourage AI investment and innovation in Europe. That's all great and exactly as it should be. I'm all for legislation, but with an all-encompassing sledgehammer approach, there can be unintended consequences, or given the socialist composition of the European Parliament, maybe it is intended. And that is that certain types of hedge funds and also private equity funds, they are going to be impacted by this legislation, but more on that later.
What's your thoughts on the intended purpose, I guess, and then we'll go into the unintended consequences later on. But yeah, what are your thoughts there?
Yeah, look, the act is intended to ensure the safety of AI systems in the EU market and provide legal certainty for investments and innovation in AI, whilst at the same time minimizing associated risks to consumers as well as compliance costs to providers. So it's a pretty wide safety net that they're casting here across AI. Clearly, we need guardrails, and I think some of this is very sensible. But as I mentioned before, there can be unintended or indeed intended consequences, and that's what we'll focus on here as well.
That's great. And so, kind of, who will this apply to again, in a broad scope?
The Act will apply to both providers and deployers of in-scope AI systems that are used in or they produce an effect in the EU, irrespective of their establishment. This means that the providers or deployers of AI systems in third countries, such as the US, will have to comply with the Act if the output of their system is used in the EU. So investors in this space need to be aware of the ramifications of this Act. It's going to hit everybody who's investing in AI, as well as those who are deploying and designing AI systems.
So does this affect issuers of AI, companies like OpenAI, for example?
Yeah, it's the definition is super wide. So the Act actually covers all AI systems. They've adopted the OECD definition, and an AI system is a machine-based system that infers from the output it receives how to generate outputs such as predictions, content recommendations, or decisions that can affect physical or virtual environments. It's a super wide definition. In other words, it covers everything that we know AI to be. The good news is that the Act uses a kind of risk-based approach, and we like risk-based approaches. We're used to seeing them, for example, with anti-money laundering legislation. And they set out 4 different risk classes, each of which is covering different types of AI systems and uses. While some AI systems are banned entirely, barring narrow exceptions, the Act imposes specific obligations on the providers and deployers of so-called high-risk AI, including testing, documentation, transparency, and notification duties. It's actually all very sensible. But on a real sort of deeper dive, the Act classifies AI systems into 4 different risk categories, depending on the use cases. So the first one is those that have unacceptable risk. The second, those that have high risk. Third one, limited risk. And the fourth one, minimal or no risk. So far, pretty easy to understand. That's all great. AI systems that create unacceptable risk, they contravene EU values and are considered to be a threat to fundamental rights. They are banned in the EU. So what are those? So, for example, biometric categorization systems that use sensitive characteristics, political, religious, philosophical beliefs, or sexual orientation and race, untargeted scraping of facial images from the internet or CCTV footage to create facial recognition databases, emotional recognition in the workplace and educational institutions, social scoring based on social behavior or personal characteristics, AI systems that manipulate human behavior to circumvent free will, AI used to exploit the vulnerabilities of people due to their age, disability, social or economic situation, and certain applications of predictive policing.
Those all fall into the category of unacceptable risks.
Banned.
These are all banned. Other than, for example, if they're being used for military or defense purposes,
Right.
or they're open sourced. So I think we can all agree that what I've just kind of basically sort of said, that's all stuff which is banned. That seems fine to me. I think that the next category is where there's going to be a lot more sort of debate. And in the second category, these are AI systems with significant potential harm to health, safety, fundamental rights, environment, democracy, and the rule of law. These are classified as high risk.
That's a second tier. This is considered.
This is the second tier. They include certain critical infrastructure, for example, in the field of water, gas, electricity, medical devices, systems to determine access to educational institutions or for recruiting people, certain systems used in the field of law enforcement, border control, administration of justice and democratic processes, and biometric identification, classification, and emotional recognition systems. These are all cases which are annexed to the Act and which are considered to be high risk. The Commission will ensure that this list is kept up to date and relevant. Systems on the high risk list that perform narrow procedural tasks or improve the results of human activities, and they don't really influence human decisions or do purely preparatory tasks, they're just not considered high risk. However, an AI system shall always be considered high risk if it performs a profiling of human persons.
That makes sense.
Yeah, look, the risk categorization is based on the intended purpose of the AI system in line with existing EU safety product legislation. It means that the classification of the risk depends on what the function is being performed of the AI system.
Okay, so you
makes
kind of mentioned and I'm sure there's a couple more breakdowns. Or that's the second tier. Then you kind of go into the next tier of the risk.
Yeah, look, the third tier is kind of what you'd expect. It's classified as limited risk. They're chatbots, certain motion recognition and biometric categorization systems, as well as systems generating deepfakes. They'll be subject to minimal transparency obligations.
That makes
I think you've seen in the news that Google and Facebook, X, that they're starting to kind of, if there's an image, they're going to be saying whether that image is from AI, whether it's real or whether it's from the real world. That's the transparency obligation of this act. It's already coming. It's already here. It's already being adopted by the global players. But the transparency requirement, they'll include informing users that they are interacting with an AI system, or marking synthetic audio, video, text, imaging, content that has been artificially created.
Okay, that makes sense. I guess obviously, so with this, what are the penalties for non-compliance with this act? I think I read a few different things on this topic, but it sounds like there's a few different aspects around penalties. I'd love to hear your thoughts there.
Yeah, I mean, it gets quite quite tasty when it comes to what the ramifications are if you end up fining it. But the fines are similar to calculations under the European General Data Protection Regulations. The fines for violation, that they're calculated a percentage of the liable party's global turnover in the previous financial year. So whichever is the higher. 35 million or 7% for violations which involve the use of banned AI applications. 15 million euro or 3% for violations of the Act's obligations, and 7.5 million or 1.5% for the supply of incorrect information. So, just like with data protection, you've got to have your ducks in a row here. You've got to comply.
So not minor penalties is what we're talking about. It's pretty hefty here.
Yeah, it's pretty hefty, but also for those who are involved in designing AI, I just mentioned, Google and X, they're already in the process of compliance effectively, but they're looking at it that they need to do it anyway. And I think that is certainly the right approach. But in addition to that, they'll need to look at this act and how it impacts them.
Yeah. Any insights into the enforcement of these? So how do you have any insights in terms of like how is the European government going to like see that somebody's doing facial recognition, these type of things that are banned, for example?
The act will be primarily enforced through national competent market surveillance authorities in each member state. So, in other words, every member state of the EU is suddenly going to have an AI surveillance unit. Additionally, a European AI office, a new body within the European Commission, will be created to take up various administrative, standard setting and enforcement tasks. The European AI board is going to be comprised of member state representatives and will be kept as a coordination platform and to advise the Commission.
And so, Ian, early on we talked about unintended consequences, kind of related to the hedge fund managers. Can you expand on that? What you meant by that?
Yeah, obviously, this is the most relevant part for our clients in the audience here. Given the extremely wide definition of AI by the OECD, which is followed by the EU Act, it is wide enough to include all forms of trading algorithms. And this is what I alluded to earlier. Is it intentional or unintentional that not only investment managers running cryptocurrency and digital asset trading algorithms, but also mainstream TradFi investment managers running high volume trading funds using algorithms, both will be caught by this legislation. If one of the founding pillars of the legislation is to protect the consumer, this seems to have been extended to protect the typically professional investors in hedge funds that use trading algorithms. I really just don't see why the EU feel that this group require protection in addition to those already afforded to them under EU financial services regulations. And also, given that they've made an informed decision to invest in the fund, that they have all of the disclosure documents to make that determination, I just don't know why the EU feels that the professional investor needs even further protection when it comes to AI, particularly with the trading algorithms. But right now, that is how it's looking. As to which of the four categories will apply, well, I've been chatting with my friend Dean Armstrong, KC, here in the UK. He's a data protection and AI specialist. Through him, I've become very interested in this area of AI. His view is that until there is more clarification from the EU, a trading algorithm needs to be treated as high risk. Although a trading algorithm is not even close to one of the examples given in Annex 3 of the Act, I accept the logic to Dean's position, and it's certainly the safest position to take. Therefore, investment managers running trading algorithms in a fund which has EU investors will need to undertake an independent review and determine whether their AI is high risk. The EU call this a conformity assessment, which needs to demonstrate that their system complies with the mandatory requirements for trustworthy AI. That means data quality, documentation, traceability, transparency, appropriate disclosures, human oversight, accuracy, cybersecurity, and robustness. And this assessment has to be repeated if the system or its purposes are substantially modified. So, providers of high-risk AI systems will also have to implement quality and risk management systems to ensure their compliance with the new requirements and minimize risks for users and affected persons, i.e. investors, even after a product is placed on the market. My own view is that if your algo is designed around pure price data, i.e. the algo literally uses price points for commodities, equities, cryptos, straight off the exchanges, you're going to be the lower end of compliance here in terms of what you've got to do. But if your algo also uses any form of sentiment analysis from, say, social media, Twitter or X, which measure the emotions, opinions, and attitudes of market participants towards certain assets, events, or topics to help you, i.e. the algo, gauge the level of optimism, pessimism, fear, greed, or uncertainty in the market, which can affect price movements and trends, then you will need to be disclosing this and any bias in that system. It's all about bias. If there's bias in your system, that's what's going to be disclosed. That could be your secret source. You're going to have to disclose it.
That's pretty interesting. That's that's very impactful, right? To a fund manager who has sentiment data or is running these algorithms, how they have
Yeah,
to.
I mean, when you speak to so many crypto managers, they're really mainly using pure price data,
Right.
but they're interested in the sentiment data as well. So if they're using sentiment analysis in line with pure price data, they will need to be disclosed exactly how they're running their algos.
Is there
But
any
as to who's
standard?
going to be, sorry.
Is there any standardization around that valuation process? You mentioned a few different data points or things that need to be done from a valuation perspective, testing, the model. Is that? I'm sure that's going to be iterative as we go forward. Is there a kind of a set template or standardization process that they've outlined for these firms that are using these algos
Um,
or data?
I'll come on to that next. But what I'll say is, as to who's going to be running the conformity assessment and AI compliance, well, just like with ESG specialists,
Yeah.
AI specialist offerings, they're going to spring up. And some will no doubt be offered by global fund administrators. It's just going to be another compliance expense. So the
Yeah.
investor pays for the EU Act compliance, even though they didn't ask for it, and even though they don't necessarily want it. It's going to be here. It's going to be required to be adhered to. It all comes down to disclosures, or the transparency and disclosures. And I think that the lawyers, or along with the conformity assessment specialists, will work together and put together the appropriate disclosures that are going to be needed for the offering documents. Ultimately, that's where this goes. There's lots of other things there as well which need to be done: storage of information, etc., risk assessments. These are all things that will have to be done as part of the overall compliance. But the piece that the investors are going to see is going to be disclosures.
Yeah, that's definitely interesting. It sounds like more valuation of more cost to the fund manager to make these assessments if they're kind of in this kind of navigating these waters. If their strategy is
Oh,
focused on
absolutely,
algos,
absolutely. And now the EU's done this, it's all going to be about what the US do and how the UK operate as well. So this is definitely going to be a new industry or new springboard for compliance experts, and another hope for managers to jump through.
Yeah. Are there any, besides obviously you mentioned quantitative funds, that's the obvious type of fund that would be affected. Are there other types of funds that you could see might be disproportionately, affected by this act?
Anyone that's running an algo, so your typical crypto manager is running an algo. So it's a question of what does that algo look like, how much needs to be disclosed in respect of the algo, um, and how their AI is being used. It will come down to whether it's pure data or whether it's sentiment data.
yeah. When does kind of all this? I know there's different things based on when this all goes into effect, right? Any thoughts around kind of when this all is becoming final?
Yeah, so the AI Act will surely be officially adopted by the European Parliament and the Council and published in the EU's official journal. That's when it enters into force, well, 20 days after the publication in the official journey. It's likely to be this summer. So
Okay.
sometime June, July, it will become law. But the majority of the Act's provisions will apply after a 2-year grace period for compliance, so sometime in 2026. But the regulations prohibitions, i.e., those are the AI stuff that's banned, that will apply after 6 months. So from June 24, that they'll be banned by the end of the year. The provisions for the high risk obligations on AI, they'll come into force after 12 months. So it'll be the summer of 2025. It's all a bit confusing. It's the EU. It's kind of the nature of the beast.
Yeah, it's definitely interesting. I kind of hear different narratives. Obviously, when you're trying to preempt known issues and the fact that this market's moving so fast from an AI perspective, technology, generative AI, that's a whole nother ball of wax we're talking about here as well. And how, obviously, as you mentioned, the unintended consequences of just putting out a blanket act like this, they'll be give
I
and
think
take on
that
both sides.
developers of AI, they know this is here, so they are being invited to join an EU AI pact, which will be launched by the European Commission. In other words, it's an EU sandbox. And here, AI developers, they can commit to implementing key provisions of the Act voluntarily prior to these respective deadlines. And during this great period, much work is going to be done by EU member states and at union levels to establish effective oversight structures. Guidance publications will go out on the implementation of the Act. The EU's never been good at this. ESMA being a great example, and AIFMD being another. But that's it in a nutshell. Here's where we are with the EU Act. For us, the big thing is now is going to be what's the UK going to come up with? What's the US going to come up with?
Yeah, so I get
Yep.
absolutely. So the implications, obviously, U.S. I mean, we don't have a current act. We kind of let the corporations and firms govern, their data governance and AI process to this point, right? But we're going to have to
Well,
look at everything.
Biden put out the executive order in respect of AI. Okay, great, but that's going to be followed up now with sort of legislation.
Right.
So something has been said by the US. UK's remained pretty quiet on the sidelines. They are just watching what happens with the act and sort of seeing what works, what doesn't work, and coming up with what we hope will be sensible legislation.
Any
Yeah, that
thoughts
makes
on
sense.
how this will affect the EU? Do you see companies kind of just moving away so they don't need to comply to this, or do you see more companies kind of changing their opinions on what they want to do?
I'm a great believer that the cream rises to the top. I think that those who are serious developers of AI, they're well backed. They'll be looking to comply. It's a great badge to wear, effectively, that you are complying with this piece of legislation.
Yeah. Especially, I mean, to your point, I mean, which I think is good, is they provided a kind of a sandbox to avoid any violations, to kind of work collaboratively together to come up with what is the best practice here going forward, right? Which I think is a good thing.
And bear in mind that this also implicates anybody outside the EU. So if you're developing AI in the US, but you have EU consumers, you will be caught by this legislation.
Yeah, just like GDPR, that's, I mean, everything
Yeah, no,
is
no. And frankly, that's how it should be with
yeah.
this particular industry.
Obviously we talked about the fund manager. What advice would you give a fund manager kind of looking into this, or if he potentially is at risk of his current trading algos, he has to comply with this? What would your, I mean, so from an assessment point of view, from a starting point, what would your thoughts be to a fund manager kind of looking in this space and saying, hey, how do I kind of navigate these waters going forward?
Yeah, when I check with managers that run trading algos, the first question I ask is, "Tell me about the algo. How does it work?" And if they answer the question in depth, that's brilliant, because that's exactly what they're going to be expected to answer investor questions on a DDQ,
Mhm.
and how they're going to need to be disclosing that information in their offering documents. So I think that it's managers are going to need to be more aware that they're going to be asked these questions and they're going to need to have the answers.
So being prepared up front with an assessment, evaluation of with how they're running their
Yeah,
algos.
they'll need the third party assessment anyway in order to deal with the compliance, to fundamentally assess where their AI fits within the four categories. Um, and over
Disclosures.
time, it will become more clear as to which of the categories trading algorithms actually fit into. Because I think right now we're saying, or it's being said, that it should be deemed high risk. I think over time that will change. And I think the EU will probably put something out in respect to trading algorithms and say it's not high risk.
Makes sense.
But it also depends on exactly how your algorithm is structured, and whether there is any bias built into it.
Yeah. What about like fund managers, using different AI systems just for their course of business? I mean, I think AMA put out a recent white paper. 86% of fund managers are using AI, some element of AI, internally, just operationally, or just to help their, do things faster, quicker, more efficiently. Would that be any effect here? I mean, we're talking algorithms, but that's a separate conversation,
Right.
I
Even somebody
guess.
looking at research using AI to maybe identify trends, things like that.
Yeah.
Yeah, no, absolutely. I mean, that's all relevant here. That all gets tracked. That gets caught by this legislation. So it's
Right.
about looking at your business as a whole and saying, right, okay, so what AI do we use? How is it used? Um, and are there any biases built in this, or is it merely AI which um, makes tasks that would ordinarily be performed by humans, they're done by machine now, and it's faster?
Yeah.
So I think it all depends on the AI that's being used and how it's being used.
Yeah, that makes sense.
And
Well, to me, what I'm hearing is basically anybody who is using or touching AI from a software solution perspective should really just like anything from a SOC, report on an annual basis where you're audited. You have to kind of outline your operational controls related to that technology. This is no different. We're going to have to include that as well as part of the framework of other service providers, how we interact with them, what they do from an evaluation standpoint. Is that accurate to say?
It is. It's no different from compliance from sort of ESG or data protection, anything else. Um, have you got your an AI compliance framework in place? Yes. What does it look like? It looks like this. Who put it together for you? It was a third party. It was these guys here. Okay, great. Have you got all the requisite disclosures built into your offering documents and investor questionnaires? Yes. Okay, great. The auditor will go away and think, right, they're clear in respect of their compliance, so we know that there's no potential fines that are come down the pipeline that would impact our audit, basically.
Right. So there'll be additional disclosures from an AI perspective. It sounds like based in the offering docs of a fund potentially going forward now that maybe weren't there before. Is that?
Absolutely. Look, it's a new piece of legislation, so it's new in respect of how you comply with it. We know how we're going to comply with things, but it's a question of getting it done. During the course of this year, people need to be preparing themselves for compliance, which will take place in 25.
That's great. Great insight there, Ian.
We've got plenty of time to get this done, but let's start focusing on it now, rather than suddenly it's summer 25 and everyone's being inundated with risk assessments or compliance assessments that need doing.
Yeah, it's always better to work on it now and get ahead of the game before the final exam, shall we say? Before you
I think to be fair, particularly in the crypto community, look, the algo is central to what they do. They're very proud of their algo, how it's been constructed, and they want to talk about it. That's brilliant.
Yeah.
So here it's just about putting it down in the offering document and disclosing how it works. Now, clearly, no one wants to give away the secret sauce. That's not part of this. It's just making sure that there's no bias built into any of the data that's coming through.
Yeah,
that's great.
I think that makes a lot of sense. So yeah, definitely people should start thinking about that now.
No, curiously, I actually do think this makes sense. Obviously, nobody wants it within our community, I'm sure. It's just a further additional compliance expense. It makes sense from a EU consumer perspective in terms of the overall act itself and what it's doing. The fact that it catches investment management, I don't think it should, but it does. We can address it. It's not a gigantic drama.
Yeah, well, at least we can identify. Here's the reality, right? Whether unintended or intended. Here's where we're at, current state, and here's how we need to think about it going forward.
Yeah, I think the concern would be more no one's picked up on this because people aren't really talking about this so much in terms of the AI Act and how it impacts investment managers. But we believe it does in the scenarios that we described.
Yeah.
No, those are all great points. Yeah, that's great.
Yeah, we appreciate your insights, Ian. We appreciate you staying on top of this and keeping everybody informed. Where could people go to connect with you and learn more about yourself and your company?
Yeah, you can reach me at cummingspepperdine.com, and you can reach me at ian.gobin@cummingspepperdine.com.
Fantastic. Awesome. Well, we really appreciate the time today, Ian. This has been great.
Wonderful, guys. Thank you very much for the opportunity to chat about this topic. It's a topic that I'm really enjoying getting deeper on every day.
Amazing.
Awesome. Thanks so much, Ian.
Thanks again for watching. We hope you enjoyed this conversation. Please make sure to like and subscribe for more content like this, and check out the links in the description below to connect with us and Ian.